that you can, ironically, that you can strike down an ordinary law also on account of the basic structure. In fact, Justice Matthew's observation is more like an obiter. There is no plus and minus. He simply says it can't be. Why not? Nobody
doesn't explain
so
that.
my humble view is that tomorrow if a matter comes before the High Court or the Supreme Court and if it's violating basic structure as enumerated by the Supreme Court, even an ordinary law can't pass muster. Okay.
Much less an ordinary law. Passing.
Yes, you're right.
Yeah. Thanks. Now my pleasant duty to make the closing remarks. Thank you all for coming, and I must tell all of you that this is an absolutely fabulous book. What I liked about the book was that Justice Nariman has taken the trouble of taking the minority judgment. You see, we keep on saying Keshan Bharati, Justice Khanna and basic structure, but nobody bothers to see what are the minority views. If it was 7:6, there must be a very strong ground. And as Justice Viswanathan said, the judgments of Justice Palekar, Justice Matthew, Justice Chandrachud, extremely closely reasoned and very, very compelling reasons not to accept basic structure. And one must put ourselves in a time machine and see those times when they thought. And it is ironical that all of them said that we can't imagine any parliament doing something outlandish, as Justice Nariman said. And it's a strange irony that within a few years after basic structure, you had the 39th Amendment, which exactly did what people said could never have been done. The beauty of this book is that he has taken the minority views and then given his comments as to why it is not correct. The other important thing I say, those of you who buy this book, please make a note, please go to page 302 of this book. And it is an irony that Justice Saqib Nisar of the Pakistan Supreme Court has made a table, it's amazing, where he has made like an Excel sheet, all the cases from Keshan Bharati, Indira Gandhi, Minerva Mills, Vaman Rao, Sampath Kumar, Samba Murthy, and he has highlighted which are the points of basic structure, which judge said what. So this is really a remarkable thing which Justice Nariman has taken the trouble of finding out. And he has also mentioned how the law has developed in various countries. Those of you interested, perhaps the best book on this is Yaniv Roznai's book, Unconstitutional Constitutional Amendments, where he has studied 700 constitutions from past thing, and then he goes into various cases where the basic structure has been adopted.
He also commends Keshwan and the Bharati.
Yes. And he says India is the forerunner. Singapore and Pakistan, Singapore and Sri Lanka have not accepted it because their constitution permits complete abrogation of the constitution itself. And I just mentioned one thing because I was involved in writing this Courtroom Genius with Mr. Sorabji, and I had the benefit of doing large number of interviews, including late Justice Y.V. Chandrachud. And I'll just mention a story that Keshan Bharati may not have been necessary if Palkhiwala, that's what, there's a very famous solicitor from Bombay called D.M. Popat. Yes, of Mullah and Mullah. Sajjan Singh was being taken up. And mind you, in Keshan Bharati, like in Sajjan Singh, it is just not His Holiness Keshan Bharati. The second petitioner is Raghunath Rao Ganpat Singh and a Nawab. And there are other petitioners who are sugar mills and mining mills and so on. So they also were actually in the litigation. Similarly, in Sajjan Singh, there were a large number of industrial companies which were involved. Sajjan Singh had challenged the 17th Amendment, where at one stroke, 44 laws were put into the basic, into 9th schedule, and it was completely held unchallengeable. Just for a passing moment, Nariman makes a very compelling reason that if 31B itself is violative of basic structure, because you can't have such a situation. Anyway, so coming back to Sajjan Singh, Palkhiwala was briefed for 3 sugar companies to appear, and he hated to wait. So he told Popat that when the matter is coming up, I'll come and argue the point. And in the discussion, he mentions it in Gujarati. And what they were discussing, Popat and Palkhiwala and others, were that, look, if you say amend, can they take away freedom of speech? Can they take away 21? These were the actual questions. So he says that, is there some line beyond which the parliament cannot cross? So he said, well, let's put this point to the Supreme Court. He was going to argue the next day, but Justice Gajendra Gadkar said, arguments are over, we are not going to wait for anybody, and the arguments closed. So one of the ifs of history was, if he had been there, because it was 3:2, Sajjan Singh. So one argument, if Palkhiwala was there, maybe it would have been 2:3, and Keshan Bharati may not have been necessary. But that's just one of the histories of this thing. Other thing I'll mention is Dieter Conrad's article. I managed to get a copy of the original article, which is underlined by Palkhiwala. And if anybody is interested, please tell me, I'll mail it to you. And in this article, which is underlined by Palkhiwala himself, as Mr. Nariman mentioned, it's an article written in 1966, delivered, I think it was Banaras Hindu University. He had lectured in Banaras University. And he makes a very important point. He has seen the 1965, just after the Sajjan's 17th Amendment. He makes a very interesting observation. He says out of 17 amendments, 5 are for political reasons, state reorganization and so on and so forth. But he said the very surprising thing of the Indian system is that almost every amendment is to overturn a Supreme Court judgment. And he says that destroys the trust in your system. So he makes a very strong observation that if every judgment is going to be overruled by an amendment, then it's not healthy for the rule of law. And of course, the other point meant. But it's a very, very compelling article, which is worth reading. And it's almost deja vu, like what he expects what to happen. And he concludes by saying, I hope that India will have a brighter future and so on and so forth. So this is as far as Conrad is concerned. Friends, we've had a wonderful evening. And I would definitely say that this has added a great deal to the scholarship of basic structure doctrine. Is something which you should not forget. And I'll conclude by saying that the main criticism of basic structure is that it is anti-democratic and counter-majoritarian. I'll only submit in my own view is that the purpose of basic structure is not anti-democratic and counter-majoritarian. It's actually to protect democracy from a majority. Thank you.
Thank you.